Let's talk about the landmark Supreme Court case Hernandez versus Texas of 1954. From the Bracero Program in the 1940s, where many Mexicans who arrived in the U.S. to work experienced expensive housing, low wages, and exposure to chemicals, to Operation Wetback in the 1950s that sought to remove Mexican laborers, criminalizing them through propaganda and deporting them in high numbers. Then, the Hart-Celler Act of 1965, which further pushed the criminal narrative onto now undocumented Mexicans who resided in the U.S. And finally, Brignoni-Ponce in 1973, which showed how constitutional law can reject overt racism while sustaining racialized environment. Hernandez versus Texas raised another constitutional question. If Mexican Americans were legally considered white, why were they still denied constitutional protection? Hernandez versus Texas is a case that came before Brignoni-Ponce, but confronts the notion that even if Mexican Americans were classified as white, they were systematically excluded from juries and treated as a separate racial class. What is the case? Well, in 1951, a young Mexican American cotton picker, Pete Hernandez, was accused of murdering Joe Espinoza and charged with life imprisonment by an all-white grand jury in Jackson County, Texas. Hernandez's attorneys appealed the indictment, claiming that Mexican Americans were barred from juries, and since no person of Mexican descent served in a jury in Jackson County for over 25 years, it violated Garcia's right to a fair trial. The case was appealed through Texas state courts, where convictions was upheld that the 14th Amendment only protected African Americans and whites. The court held that Mexican Americans constituted a class apart and were not included within the category of white for constitutional purposes, especially when subjected to systemic discrimination. On May 2, 1954, the Supreme Court ruled that the exclusion of eligible jurors due to their ancestry of national origin violated the Equal Protection Clause of the 14th Amendment. The case affirmed that the 14th Amendment's Equal Protection Clause applies to all racial ethnic groups facing systemic discrimination. One thing to note about this case is that the attorney had to prove discrimination in Jackson County, Texas. The attorney had to prove that people of Mexican descent constitute a separate class in Jackson County, distinct from whites. The attorney collected the testimony of officials and citizens that admitted that residents were distinguished between white and Mexican. Children of Mexican descent were required to attend segregated school from 1st to 4th grade, and at least one restaurant in town predominantly displayed a sign that announced, "No Mexicans served." Even on courthouse grounds, there were 2 men's toilets. One was unmarked and the other was marked "Colored men" and "Hombres aquí," men here. Once the attorney was able to establish the existence of a class between white and Mexican, they had to prove the burden of discrimination. The attorney used Norris versus the state of Alabama, which was a case that proved that African Americans constituted a large population of the jurisdiction and were qualified to serve as jurors, but none had been called for jury service. This helped prove that 14% of the population of Jackson County were persons with Mexican or Latin American surnames, and 11% of the males over 21 bore such names. The state of Texas claimed that there was no record of any person with Mexican or Latin American names having served on a jury commission, grand jury, or petite jury in Jackson County. They ended up stipulating that there were some male people of Mexican or Latin American descent who were citizens who were eligible for jury service. The Supreme Court ruled in a unanimous opinion delivered by Chief Justice Earl Warren. The court held that the 14th Amendment protects those beyond the 2 classes of white or African American and extends to other racial groups and communities, only depending on whether or not it can be factually established that such a group exists within a community. The court concluded that the 14th Amendment is not directly solely against discrimination due to a 2-class theory. Mexican Americans were a special class entitled to equal protection under the 14th Amendment and had the right to serve on a jury. The man convicted, Pete Hernandez, had a retrial with a new jury that consisted of members of his own class, which in this case was Latino or Mexican Americans. He was still found guilty and sentenced to 20 years in prison. This case set precedent for challenging discrimination based on national origin and ancestry. Why is it relevant today, and how does it compare to Vasquez, Perdomo versus Noem in 2025? Vasquez, Perdomo versus Noem is a federal lawsuit filed in the U.S. District Court for the Central District of California by 5 individuals and 4 organizations. It challenges DHS and federal immigration agencies' practices during Southern California raids, alleging racial discriminatory, suspicionless stops, warrantless arrests, and denial of access to counsel at the B-18 detention facility in Los Angeles. The key constitutional claims of this case claim that the Fourth Amendment was violated because immigration agents conducted stops without individualized reasonable suspicion, relying on race, ethnicity, language, location, and the type of work that they do. They also claim that it violates the Fifth Amendment because detainees at B-18 were denied meaningful access to legal counsel. On July 11, 2025, the court issued a temporary restraining order. It's a stop arrest temporary restraining order that prohibited agents from stopping people without reasonable suspicion and barred reliance solely on 4 factors, including apparent race or ethnicity, speaking Spanish or accented English, presence at certain locations like car washes, bus stops, and the type of work that they're doing, like construction. The access detention temporary restraining order required restored attorney access and confidential phone calls at the B-18 facility in LA. This case shows modern reliance on Brignoni-Ponce style reasonable suspicion, where race and related proxies are formally limited but remain operative in practice. This demonstrates a continuity of racialized policing from the 1970s to today. The Supreme Court reflects how higher courts are currently interpreting constitutional limits on immigration enforcement, still permitting race-related factors to contribute to reasonable suspicions in ways reminiscent of Brignoni-Ponce. I said in my previous video, the law can claim neutrality while operating on discrimination, and while the Supreme Court ruled the stops based on apparent ancestry, referring to Brignoni-Ponce, the law still filters who belongs based on racialized assumptions, even if individual, like in the case of Perdomo versus Noem. Racialized profiling still exists. It's still there, it's very much present today, and with the consistent constitutional violations we are seeing from many ICE agents, it is important that we are aware of the history in the United States so that we can figure out ways to tackle it going forward.
Hey, no fear, immigrants are welcome here.
No hate, no fear, immigrants are welcome here.